Pets, they're just like people, except in any meaningful way. Though the vast majority of Americans have a pet. According to a survey from the American Pet Products Association, 67% of US households have at least one pet. This goes all the way to the White House. Some American presidents hate dogs and would never have one in the White House, and other US presidents employ bloodthirsty killing machines on White House grounds. And while we tend to think of our fur babies as our own children, what rights do they really have? Even though there's no rule that says dogs can't play basketball, could a cat inherit millions of dollars? Could a dog run a Fortune 500 company? Could a monkey own a copyright? Or could an elephant run for office? Well, the answer is it depends, because it always depends. But let's find out what rights pets actually have, because this is America, and you better believe that this has wound up in American courts before. And it's going to end up in courts again. And perhaps the only thing that Americans love more than lawsuits is their pets. In 2019, Americans spent a record $95.7 billion on their pets, which makes sense. When it comes to our animal friends, most of us would spare no expense to ensure that they are happy, healthy, and pampered. Like Meowalexander Hamilton here. What happens if you want to make sure that your own Meowalexander Hamilton is taken care of in the event of your untimely death? Well, that actually raises some interesting legal questions. Let's start with the basics. Well, many of us may treat our pets like people. Legally speaking, pets are actually considered property in the United States. As a result, animals lack the legal ability, also known as capacity, to enter into a contract. Capacity refers to one's demonstrated competence to understand one's actions and enter into a legally binding agreement with another through mutual assent. And while we may think that our pets understand us when, after maybe one too many scotches, we tell them about the challenges of running your own law practice and a YouTube channel, under the law, they do not. And since animals are property under the law, they can't enter into contracts. That means that they cannot legally receive or own property. As a result, an owner's attempt to directly leave property to the pet will fail. In the case of In Re Estate of Russell, a California Court of Appeals addressed whether a pet owner can legally divide her estate between a close friend and her dog, Roxy Russell. And the trial court held that despite the language in the will directly leaving property to Roxy the dog, the owner actually intended to leave her entire estate to the close friend to care for the dog. But the Court of Appeals rejected this interpretation, holding instead that the will unambiguously sought to divide the estate between the friend and the dog. The court further rejected any argument that the pet owner had created a trust to care for Roxy, as the will did not demonstrate a specific intent to impose on the friend a duty to care for Roxy. Ruling that a dog cannot be a direct will beneficiary, the court concluded that the gifts to Roxy were invalid. And accordingly, half of the owner's estate that had been intended for Roxy as a matter of law went to the owner's closest relative, her niece. So to avoid problems like the Russell case, as of 2016, all 50 states and DC have passed laws regarding the creation and use of so-called pet trusts. A pet trust is a legal arrangement that outlines how your pets shall be provided for and taken care of financially in the event of your untimely death or disability. And in the vast majority of cases, pet trusts and gifts are non-controversial. On occasion, they make international news, especially when millions of dollars are at stake. Like for example, in 2007, when Leona Helmsley, a New York billionaire real estate developer, left her Maltese Trouble $12 million in a trust fund. Known as the Queen of Mean for her acerbic personality and the way that she mistreated her employees, Helmsley also specifically disinherited 2 of her own grandchildren in her will, quote, for reasons which are known to them. Ouch. However, in 2008, a New York judge slashed Trouble's inheritance from $12 million to $2 million on the grounds that Helmsley was mentally unfit when she made her will. As a result, the 2 disinherited grandchildren received a total of $6 million. And despite her Queen of Mean reputation, Helmsley clearly had a soft spot for her dog Trouble, who died in 2011, presumably on a bed of lots and lots of money. Though parenthetically, that's not the only thing that she had a soft spot for. She also had a soft spot for not paying taxes. Famously, she said, "We don't pay taxes, only the little people pay taxes." And in 1989, Helmsley was convicted of federal tax income evasion and other crimes. It turns out that not all abrasive New York real estate developers who mistreat everyone around them get away with not paying their taxes. Though sentenced to 16 years, she only served 19 months in prison and 2 months of house arrest. Though Helmsley was not alone in leaving obscene amounts of money to her pets. In 2019, German fashion designer Karl Lagerfeld died, and upon his death, it was revealed that Lagerfeld had left a chunk of his near $300 million fortune to Chopette, a Burmese cat. Though the pair lived in France, which prohibits pets from directly inheriting their owner's property, under German law, which governs Lagerfeld's will, pets may inherit property. And in June 2020, it was reported that not only were there 7 other human beneficiaries, but none of the human heirs heirs had been able to gain access to their share of the estate. That's because Lagerfeld's octogenarian accountant, Lucien Friedlander, the only person with enough knowledge of Lagerfeld's vast estate to aid in the distribution to the beneficiaries, mysteriously closed up shop in September 2019 and has been avoiding everyone's calls. Friedlander's wife insisted that her husband has not, quote, run off to an island, but is simply just too sick to work on the case. But of course, that definitely sounds like the sort of thing that someone who was hiding away on a private island might say. So while Lagerfeld's beneficiaries fight for their inheritance, Choupette does not even need the money. The famous feline, who has hundreds of thousands of followers on Instagram, already earns millions of euros each year by appearing in advertising campaigns, on magazine covers, and even has her own wine brand and makeup line. She's basically the cat equivalent of the Kardashians. Clearly, I'm in the wrong business as a lawyer and should have pursued a lucrative career as an international multi-millionaire cat model. So yeah, I guess I'm saying if anyone needs a YouTube bird model, give me a call. But the past is the past. Speaking of which, remember in 2019 when a banana taped to a wall sold for $120,000? If you found yourself asking, did a monkey make this? Well, not this time, but there is plenty of animal-made art out there, like Pockets Warhol, a capuchin monkey who's been painting since 2011. And then there's Lucky the rescue elephant painting in Cambodia. And while seeing animals make art is fun, it raises an interesting question. Do these animals actually own the copyright in the works that they create? I've covered copyright law in previous videos, but to summarize briefly, copyright extends legal protection to authors of any original work fixed in a tangible medium of expression, such as paintings, songs, novels, and even photographs. The holder of a copyright owns a set of exclusive rights to make and sell copies of their works, create derivative works, and perform and display their works publicly. Now, the issue whether animals own the copyright in their artistic creations were at the forefront of what became known as the monkey selfie case. See, back in 2011, a macaque monkey named Naruto, I assume that's Naruto as in the anime and not Naruto as in Pablo, but using a camera strategically placed by British nature photographer David John Slater while on assignment in Indonesia, famously took a monkey selfie. Slater included Naruto's photos in a book he published. These photos subsequently went viral. And in 2015, the People for the Ethical Treatment of Animals, or PETA, known for their attention-grabbing protest that has made them the frequent target for parody, sued Slater and the self-publishing company Blurb on Naruto's behalf.
The outside world looks down on a man marrying a llama, but our love knows no boundaries.
Wow, you guys really love animals.
PETA argued that publishing and selling the photographs infringed on Naruto's rights under the US Copyright Act. And PETA sought a judgment affirming Naruto's copyright in the photos and requested that PETA be appointed to administer all proceeds from the photos for the endangered species benefit. The defendants countered that as a monkey, Naruto could not own a copyright. And while the case was pending, numerous copyright experts in both the US and UK argued that Slater's role in the photographic process and his artistic choices would be sufficient to grant him a copyright in the photographs, though a formal court judgment might be necessary to be determinative. In fact, in a December 14 publication, the United States Copyright Office stated that, quote, to qualify as a work of authorship, a work must be created by a human being, specifically stating that a photograph taken by a monkey or a mural painted by an animal would not receive copyright protection. And in January 2016, the US District Court agreed, with District Court Judge William Orrick writing, while, quote, Congress and the President can extend the protection of law to animals as well as humans, there is no indication that they did so in the Copyright Act. PETA appealed to the Ninth Circuit Court of Appeals, and in September 2017, both PETA and the photographer agreed to a settlement in which Slater would donate 25% of any future revenue to charities that protect the macaque habitats. Unfortunately for Slater, the damage was already done. The litigation had been financially devastating to him, leaving him broke and unable to pay his attorney or even replace the broken camera equipment. Now, after settling, PETA attempted to dismiss the case, but the Ninth Circuit refused, stating that it wanted to set a legal precedent for similar cases that would arise in the future. The panel also ripped the animal welfare organization for what it viewed as PETA attempting to manipulate the legal precedent in a way that suits their own interests. And in 2018, the Ninth Circuit did set a precedent, unanimously ruling that while humans can file copyright lawsuits, animals may not. And as a result, the court concluded that Naruto did not own any copyright in the photos. Now, the three-judge panel also excoriated PETA for its litigation tactics, accusing the organization of using Naruto as a tool for its own ideological agenda while pretending to be a friend. PETA appears to have failed to live up to the title of friend. In the wake of PETA's proposed dismissal, Naruto is left without an advocate, his supposed friend having abandoned Naruto's substantive claims in what appears to be an effort to prevent the publication of a decision adverse to PETA's institutional interests. Were he capable of recognizing this abandonment, we wonder whether Naruto might initiate an action for breach of confidential relationship against his former next friend PETA for its failure to pursue his interests before its own. Puzzlingly, while representing to the world that animals are not ours to eat, wear, experiment on, use for entertainment, or abuse in any other way, PETA seems to employ Naruto as an unwitting pawn in its ideological goals. So there you have it. The Ninth Circuit says that currently the Copyright Act does not apply to animals, but it could be extended to do so, and it accuses PETA of treating animals unethically. But that's just silly copyright issues. What about animals holding real power? Well, there have been countless movies and TV shows over the years with the exact same story. A down-on-their-luck sports team immediately changes their fortune by substituting the team's animal mascot. And they all seem to get around the very, very obvious objections to such a substitution in the exact same way. Well, show me in the rulebook where it says that we can't substitute our animal mascot of choice, who happens to be magically good at this particular sport, into our particular sports ball team. Show me in the rules.
He's right. Ain't no rules that the dog can't play basketball.
Lawyered. Just don't look at the Copyright Act, I guess. But in the real world, although there's no specific rule against substituting the entire Chicago Bears lineup with a sleuth of bears, yes, that is the actual group name for a group of bears, in part because the Bears would always be offsides, and not for nothing, they would probably rip the opposing team to shreds. But in the late 19th century, the political term, the yellow dog Democrat, described Southern voters who allegedly would vote for a yellow dog before any Republican. Now, you might be surprised to know that many voters in US history have followed that mantra by electing animals to local office. Now, generally speaking, election law regulations would disqualify animal candidates by explicitly requiring candidates to be human, or perhaps by requiring candidates to at least perform tasks that, only humans can perform, such as sign their names legibly. However, when the law is silent or ambiguous on the matter, certain localities, usually unincorporated towns, have allowed animal office holders under the same logic of Air Bud. Well, there's nothing in the election code that says we can't have a dog mayor, so let's do that, apparently, for some reason. And wouldn't you know it, in 1938, Boston Curtis, a brown mule, was put forward as a candidate for a Republican precinct committeeman in the small town of Milton, Washington. Boston was nominated by the Democratic mayor, Kenneth Simons, as a prank for two reasons. One, he wanted to embarrass the Republican Party, and he wanted to show the flaws of the primary system in which voters, quote, often have no idea whom they support. The mayor would be proven correct because humans are stupid. Boston was elected with 51% of the vote, despite not offering a platform or making a speech, and being known as someone that was stubborn as a mule. And in the unincorporated town of Lajitas, Texas, they live up to the state's reputation for demanding limited government. Since the 1980s, the town has consistently elected members of one political dynasty, Clay Henry, the beer-drinking goat. I mean, just look at him. There's a kid you could really grab a beer with. Now, this saga began when a man who had the audacity to be from Houston decided to run for mayor, and an outraged local businessman challenged him with a goat. Though the Houstonian won that election, Clay Henry won the next one in a landslide, and since then, every Clay Henry has been elected. Today, the town is actually under the leadership of Clay Henry IV. But when it comes to electing animals to office in the United States, dogs remain by far the most popular choice. In 1981, Roscoe, a black Labrador Rottweiler mix, defeated two humans to become mayor of Sunol, California. He of course ran as a Republican on an agenda of a bone in every dish, a cat in every tree, and a fire hydrant on every corner. He served his community for 13 years until his death, and there's actually a statute in his honor. Similarly, Idlewild, California is an unincorporated town and has no local government, but since 2012, the town has modeled its election as a fundraiser for the benefit of a local animal rescue nonprofit organization. Locals would nominate their dogs and cats to run for mayor. 14 dogs and 2 cats ran in the first election, and Max, a golden retriever, was elected as its first mayor. When Mayor Max crossed the Rainbow Bridge in 2013, he was succeeded by another golden retriever, Maximus Mighty Dogmuller II, or Mighty Max for short, who still leads the town to this day. His oath reads, "I, Max, do swear on my food bowl to faithfully properly execute my duties as mayor of Idlewild. The mayor's duties include meeting with the constituents in his pickup truck, attending city events, and making a variety of appearances on state and local media to promote the town. But of course, the downside of having a dog run for mayor is calls like these. Hello, this is a paid political advertisement from the mayor. My name is, and I approve this message. But on the other hand, Mayor Maximus Mighty Dog Mueller II probably saved a ton by making those robocalls with today's sponsor, Ting Mobile. And you can too. In fact, I personally switched to Ting Mobile and saved literally hundreds of dollars a month. I'm not kidding. Why? Well, because of this. Yes, this is a real cell phone bill that I got with my previous provider, and it's why I personally switched to Ting. And Ting Mobile has 3 brand new plans to make sure that never happens again. All of Ting's plans have unlimited talk and text starting at just $10 per month, so you can use their Flex plan and only pay for what you use, which is especially great if you're around Wi-Fi all day. Or you can choose a set of 12 gigabytes of data for $35, or get full unlimited for $45 a month. Switching plans is actually really easy because you can keep your same phone number and use pretty much any phone. And the service is great because Ting partners with several massive networks, probably the very same one that you're using right now, but at a huge discount. They literally use the exact same infrastructure. Now, I can't tell you which one specifically because I always respect contracts and NDAs, but let's just say that my service hasn't changed at all. And if you're around Wi-Fi all the time, like you're working from home, you still have the flexibility to save hundreds of dollars a year with their Flex plan. Now they just give you the possibility of unlimited versions as well. So if you want unlimited, you can go absolutely crazy. And it's incredibly easy to transfer service. You just order a Ting SIM card, pop it in, and set it up. No phone calls required. It's like magic. But if you do ever want to talk to Ting, you can call them up and talk to a human immediately, or you can talk to them on chat or Discord. You will talk to real humans, virtually no wait times. So if you would like to give Ting a try, Legal Eagles will get a $25 service credit that could cover up to 2 months of service. All you have to do is click on the link below and give it a try. And you can even use your last bill to compare just how much you would save with their comparison tool. So just click on the link below, plus clicking on that link really helps out this channel. And while you're there, check out this playlist with all of my other legal meme reviews and lawyer jokes, so click on this playlist or I'll see you in court.